Yes.
Okay. Good morning, everyone from Europe. Good afternoon, everyone from China. And good night, everybody from the Americas. My name is Bart Kastelein of the law firm Huyssen in Amsterdam. We organized together with IPBA with the very efficient help of Rhonda and of course Jack Lee, this conference on M&A, Chinese M&A into the Benelux / Europe. You may wonder why Benelux is chosen here. Well, simply, of course, because we here are sitting in the Benelux, and this is if you look at it as one jurisdiction, it's a mid-sized economy in Europe, and it's representative for M&A for all of Europe. So we can speak broadly of M&A in Europe. For that, we have a very well equipped speakers panel, all Chinese, including myself as the fourth member coordinator. I was born and raised in Hong Kong, so I'm also a bit Chinese. Let me first introduce the speakers very shortly to you. So first, after the welcome word from the president of IPBA, Jack Lee, we will get Chunqing, also called Winston Jin. He's a lawyer from Fangben in Shanghai. He's been in the practice since 1986. He is a very broad educated lawyer with a great international experience. In fact, he has had a lot of dealings with the Netherlands, especially with Philips, the electronics company. He's a professor in several universities, Nanjing, Shanghai, and Suzhou, and he's a well-known speaker in IPBA and other groups. The second speaker will be Wendy Liu. You see her on the screen. She has been a lawyer in Shanghai with Minter Ellison for many years, and is now in Europe, in Amsterdam, since 4 years or so. She is specialized in corporate law, and she works for our firm, Huyssen. The third speaker is Eva Tu of the law firm Monarch in Brussels. She is a corporate M&A senior associate, and her education is ECUPL, as Wendy, by the way, ECUPL in Shanghai, and then a LLM in Leuven University and the Université Libre de Bruxelles. So she is also French speaking. She's on the B list of lawyers in Brussels. So that's the speakers, and what we will focus on. Let me start by saying what we will not address. Well, first place, we will not go into FIC, foreign investment control, because that has been covered by an IPBA webinar a couple of weeks ago with Jan Bogaert from Brussels as one of the organizers. We will not cover tax, and that explains why Luxembourg, as you may have noticed, is not in the speakers panel, because Luxembourg is mainly tax driven and very close legally to Belgium and also to Holland. We're in the same group. Nevertheless, Luxembourg is, of course, also corporate-wise a very important country in the Benelux. We will not discuss whether Mr. Biden is better than Mr. Trump for all of us. And finally, we will not discuss who will be the first with the COVID vaccine. One thing we do know for sure is that China was first in producing worldwide the facial masks. What we will discuss is the trends in M&A between China and Benelux/Europe. We will, of course, not avoid the elephant in the room, which is COVID. What are the impacts of COVID? Next, we will have especially an outlook over what happens after COVID, when we're back to normal. So all the speakers will look at it from their side. And finally, Eva has been asked to, because she's from Brussels, to cover EU legislation. So the game rules of this conference are explained now by Rhonda Ludlin, who is online. So Rhonda, can you help us out here?
Yes, of course. Thank you everyone for joining today's webinar. We have turned off the chat feature for attendees because it's a little bit less distracting for the speakers. So thank you for your cooperation and understanding in that end. If you do have questions, there will be a Q&A session at the end of the webinar after the speakers are finished. So please write questions in the Q&A feature that is available through Zoom. If you're on a laptop, it should be on the bottom of your screen. And that's it. And the questions will be answered by the panelists at the end of the session. Thank you.
Okay, so let's try to exert some discipline there. Unfortunately, it's not a free interactive communication, but let's see how we can get by. And if not every question is answered by the audience, 82 people, then they can always pose their questions by email to the speakers or through Rhonda Ludlin. So now it's time for Jack Lee, the president of IPBA, I think forever, because COVID has changed the game. And he will do the welcome word for this seminar.
My dear brothers and sisters, dear distinguished guests, I'm glad to have this opportunity on behalf of Inter-Pacific Bar Association to thank all of you to join our IPBA webinar at this special moment. COVID-19 virus has been spreading out around the world, but the virus cannot stop our mutual understanding and communication. Today, our seminar focuses on the outbound investment from China into Benelux, Europe, legal issues in MA practice. The moderator is my good friend, Bart Castellan, who contributes a lot for our association. The speakers are my good friend, Chunqing Jin, Wendy Liu, and Xu Fang Tu. Thank you for your great efforts to organize this important webinar. We all know the COVID-19 brings plenty of efforts for the global trade. However, through our tireless efforts, the world trade has revived sharply. For instance, China International Fair for Trade and Service was held in Beijing early this September. And the conference attracted thousands of companies from all over the world. The first Shanghai-bound FinTech conference was successfully held 2 months ago. And the seminar on the legal service for the Shanghai International Financial Center was successfully held late September. The third China International Import-Expo held in Shanghai was successfully held this week. The Chinese president delivered a video speech on the opening ceremony. Hence, I believe the whole world will be back on track very soon. Next April, Shanghai will host IPBA 30th Annual Media Conference at the bend of Huangpu River from April 18 to April 21st. We are looking forward to meeting with all of you in Shanghai. Before closing my opening remarks, I would like to share with you our first IPBA conference song titled, "We Are Together."
手，途中血脉是会激动的追求。Spirit castle， 此心相守，智慧的手，心向前，真诚与爱，爱永久。You were born a nation and grew up in the world with different blood but common pursuit. Spirit of Asura, heart to heart, hand in hand in wisdom, love and sincere forever. We are the spirit, IPBA. We are the family, IPBA. We are forever, IPBA. We are together, IPBA.
Well, Jack,
We are together.
we are together.
Yes, we are together forever.
Can grow up in the world with different blood but common pursuit. Spirit of Surah, heart to heart, hand in wisdom, love and sincere forever. We are the spirit, IPBA. We are the family, IPBA. We are forever, IPBA. We are together, IPBA。吹动友谊的纽带，把五湖四海兄弟姐妹聚到一起来。有心梦彩，对青春的你有无限期盼，接手去点亮每一份精彩。We are the spirit, IPBA. We are the family, IPBA. We are forever, IPBA. We are together, IPBA. We are the spirit, IPBA. We are the family, IPBA. We are forever, IPBA. We are together, IPBA. We are forever, IPBA. We are together. Oh. IPBA. We are together.
Yeah.
Yes, very much so.
Well, very good. Thank you, Jack.
Yeah.
This is your hidden career. I can see that. So Chunqing Jin, can you do your speech singing, or do you want to do it just verbal?
I just would like to start my presentation. Yeah, by presenting my PPT, and I will speak out in English for sure. Ladies and gentlemen, good morning, good afternoon, and good evening. First of all, although I have some hesitation to generalize my statement regarding cross-border M&A, but I have quite some confidence in share with you my historic observations and very recent observation regarding cross-border M&A this year. This year has been unprecedentedly negative because of COVID-19. But what is still quite exciting, according to my personal experiences in terms of cross-border M&A, is that this year in March, which was a peak time negatively in China, I represented a Brussels famous company acquiring two companies in Australia, and in the meantime involving some company in the Netherlands. And we finished this. We even closed the deal by May, and we finished quickly, successfully, the integrations by September or October. And despite of somebody whose name is Trump, but you know, in this September, I received a phone call actually very early September from USA, who is the leader in the world engaged in IoT business. The in-house lawyer say, Winston, I need your help, and I need help from your team, because we have to fulfill our M&A in China and Southeast Asia, and this deal has to be closed somewhere in October. So by this Friday, we will submit the bilingual SPA. So in the meantime, also in August, a dynamic Chinese listed company whose CEO, even a young lady, offered to buy a family business located in Hamburg and Amsterdam, which is potentially a huge deal whereby the EBITDA multiplier is quite reasonably high. So I'm saying that it's so wise for IPBA to organize such an event on M&A, because for the outbound investment from China into EU and Europe, especially to the Netherlands and Belgium, actually is truly very important for the world of M&A. So my PPT's slides, one through slides 6, actually clearly shows that over the past 10 years, the outbound investment from China into EU has been quite vigorous. And however, despite the trading war between US and China, the outbound investment into the Netherlands and the Belgium is so strong. And interestingly, as I shown here, the interesting and very eye-catching phenomenon and indicators, you can even say KPIs, show that the main forces for outbound investment from China into EU now are consisting of two types of buyers or purchasers. One is state-owned enterprises. We normally say abbreviatedly SOEs. The other is a listed companies from China. So you can see some figures there. So I will focus on SOEs and listed companies' behaviors of M&A in EU. And today I will use my 10 minutes to emphasize SOE and a listed company and share something really new to us, because I'm sure most of the audience and or listeners today are reasonably knowledgeable and experienced in cross-border M&A. So you can see in my slide, left, listed companies, and on the right, Oil China, PetroChina represented, SOEs. And actually, let's see, when we deal with or help SOEs in acquiring a business or target in EU, we have to be aware that numerous Chinese authorities or semi-governmental authorities like banks actually have their fingers, from A to Z for the M&A process. Then you can see SASAC, meaning State-Owned Assets Administration Committee. And coming down, SASAC is the most powerful authority regulating SOEs. And CRSC is a most powerful authority over the listed companies. So I would say for M&A lawyers, we easily would imagine that when we draft LOI for any and all LOI for M&A projects, we have to be aware that the availability of the approvals from such authority might be the condition precedent, to the closing of those M&A deals would be contemplated upon by lawyers and the buyers and the sellers. And for the listed companies, the disclosure is always the essential element for our deals to be made. And of course, this means already a very challenging mission for buyer's lawyer and the seller's lawyer to manage the time and to gear the time and the milestones, and especially when a Chinese listed company to acquire a listed company in EU, either Euronext or somewhere else. So I would say for the SOEs deal whereby any SOE would like to acquire any European companies, I would say the central SASAC's opinion and the local SASAC's opinion and their approval is always fatally important for the deal. And last but not least, admittedly, over the past roughly 6 to 7 years, it has been practically quite tough and sluggish to move the hard currency for payment of SPA price outside of China. So fortunately, since last year, from April, I have been witnessing that, back in 2015, the famous SIP have luckily got a big event whereby the China and Singapore co-steering committee unprecedentedly agree that a special functionality got granted by international law by means of the Sino-Singapore Treaty, whereby and thereby a Yangtze River Delta Overseas Investment Promotion Center was founded in Suzhou Industrial Park, whereby you can easily organize the movement of huge foreign currency for overseas M&A, but you have to set up an SPV in Suzhou Industrial Park. And a big company, dynamic listed company from my hometown, Yangzhou, where I was born, has already been the first successful case. So this is my slide 11. And this is to show the successful case, the first one, which was quickly finished last year in Suzhou. Then, generally speaking, this functionality has 3 major advantages. Number 1 is shortened lead time. If all of the paperwork is properly done and submitted, you can finish this milestone on the Chinese side within 3 business days. And the maximum foreign currency we can mobilize out of Suzhou by this functioning uniquely by means of international treaty between Singapore and the Chinese government could be reached the level of $300 million. And so far, this is the only one all over China. So that's my very brief reporting to you all. So if you have any question, we can have some Q&A later on, which will be administered by our IPBA Secretariat. Thank you.
Thank you very much, Mr. Jin. This was interesting, and you gave us a takeaway of the free economic zone in Suzhou. Now the floor is to Wendy Liu from the Netherlands. Wendy, go ahead, please.
Yeah. Thank you, Bart. Thank you, everyone, and good morning, good afternoon, and good evening to everyone all over the world. And thank you for attending this. And I will share some my experience and my understanding based on my working experience in China and also in the Netherlands and in Europe regarding the M&A. Of course, and I will share my screen now, and if you have any questions, please feel free to raise. Yeah, so let me start first. Maybe Mr. Jin, could you please stop sharing the screen so that I can sharing mine?
Yes, let me shut down mine.
Thank you so much.
Okay.
Thank you for Mr. Jin's sharing of his experience and their insights of China M&A, which is really helpful. Yeah.
Yeah, there you are.
Yeah. Okay, sorry. Sorry, I will do. Okay, so the topic of today of my presentation is post-COVID-19 opportunities and challenges for M&A in the Netherlands. I acted as the head of China practice in a Dutch law firm, so I will focus on the opportunities and challenges in the Netherlands, and of course, as the qualified Chinese lawyer, I will share my insights regarding this as well. And later on, our friends in Belgium and also the panel will discuss and further share their insights of the M&A opportunities and challenges in their jurisdictions. So my presentation will divide it into several parts, and I think the first one we need to discuss the opportunities and also the process of the M&A in the Netherlands, the challenges, and also I will discuss some more insights of the impact of COVID-19 and screening restrictions for foreign investment. And lastly, I will share a case study with you for understanding more about this. So first of all, let's discuss the opportunities for the M&A in the Netherlands. So as far as I know, and of course, as far as you know, I think it's not really, someone will say, oh, it's not really a good time for global M&A. But I think, and also my team, we thought that they were full of opportunities. From external factors and internal factors, we can all see a lot of opportunities. For the external factors, we thought I think after the UK exit from the European Union, the Netherlands will become the first choice as the destination for investments in Europe, because the yeah, as far as we thought from the logistic factor and also the language factor, Netherlands is always the famous destination for foreign investment. And also the framework of for the screening of foreign direct investment from non-EU countries, as we will discuss later. And I think the Netherlands, we can see from the Netherlands legislation that the Dutch government will always welcome the investment from outside the EU. And also, we will discuss some M&A opportunities in post-COVID-19. As COVID-19, which is not really a good factor for the economy, but as far as we can see from the history, after a serious economic decrease, we can see an increase of M&A in the past in the post this kind of economic decrease. So we see full of opportunity for this COVID-19. And we also see some specific internal factors, which is within the Netherlands, and make the Netherlands or the Dutch market to become a more attractive market for the foreign investment. The first of all is that the Dutch government, they imposed or they launched a new labor market imbalance act, which we call that a new employment law, which released more about the burden of the enterprises. So after this new labor law, the enterprises burden for flexible using their employees will make the Dutch government be a more attractive market for foreign investment. And the second one is that there was the Netherlands Commercial Court, which just started last year, and I think it's really an interesting trend because it is the first English court in the Netherlands, which and their judgment will be recognized and can be directly enforced in the Netherlands. So it is an interesting trend, and it is unique over the world. So it brings us, or it provides really language-friendly dispute resolution choice for foreign investors in the Netherlands who cannot understand Dutch. And also the third one I would say is that Netherlands is one of the most international oriented countries in the EU cross-border economy. We can see a lot of people in the Netherlands, not all, but most of them, they command a really good level of English. So you can easily chat or communicate with them in English, which is not really common in our English native speaking countries. So and also from the history of the Netherlands, they always take highly care of their international business and the foreign investment. So we learn from these factors that they were full of opportunities after the COVID or the pandemic. Next, I will briefly introduce the share transaction, or we say the M&A process in the Netherlands. I will focus only on non-auction process, which is more common in practice. So from the very beginning, you find a target or you find a buyer, and you do a first contact, and then you enter into the preliminary phases, and of course you will enter an OI, MOU or NDA for negotiating the transaction. And if you think, okay, everything goes smoothly well, so you will start and due diligence, of course, including legal due diligence and financial due diligence, and of course, in some cases, that will be technical due diligence. So after the due diligence, there will be an investigation and negotiation, and also we will do the structure design, or you will be assisted with your financial advisor and legal advisor to check or to confirm the structure for the transaction. And also in this phase, you need to also take care of the employee participation, which is also really important in the M&A in the EU and also in the Netherlands. And upon the finalization of due diligence report, if you think everything is fine, or you need a further information, or you will see how you can deal with the material issues which was found in due diligence. So you will also negotiate and structuring again about this transaction. And after everything is settled, you will enter into the signing SPA of the whole process. And also you need to consider whether this transaction is big enough to have a merger control file, or sort of this kind of process. And after the signing SPA, everyone or their advisor will check whether there is any competition issues you need to pay attention. And if so, you will deal with that. If not, okay, then the transaction will be completed, and the post signing, the condition precedent, and the CP, we will check, and also if the CP is fulfilled, and we can go to another stage, and for the integration of the M&A, which is also really important. So that's the basic process, or a normal process for the M&A in the Netherlands. So let's focus on the challenges of the M&A in Netherlands currently. So the first, of course, everyone in 2020, we will not escape from COVID-19. So I will say something about impact in general, and also the measures for the companies. And also, I will say something about the screening restrictions, because it's really a hot topic. Everyone noted that the European Union and also the European member states and also other Western countries, they are starting the screening restrictions or imposed against the foreign investment. So I will say something about that as well. So let's first see some impact of COVID-19. So the COVID-19 impact in the economy as a whole, and also I think there were it also impacted the M&A in the Netherlands and also over the world. So the first of all, of course, we can see the difference or the varieties in between the sectors. Some sectors, they did really well, or they booming their economy or booming their business in the COVID-19, but in some sectors, they were not doing well. And so the second one I would just say is the role of private equity parties, because we do see some private equities, they are seeking for they're seeking for not the assets which encounters economy problems, and it is really a good opportunity, or it is really a big chance for them to get some valuable targets with a low price. And also some of the, as I said, in some sectors, it is not really good for their business. So they are thinking about strategy acquisitions to maybe use converted notes or use buyback and also integration with the competitors. For this kind of things, yeah, they can survive from this difficult time. And also, someone will say, okay, is it a bad time for M&A, or it is a good time for M&A? So from my personal point of view, I would say it will be a good time for M&A. Although the transactions at this moment is not that good. So after the economy decrease, I think a lot of or the whole economy, they will integrate it again, or they will, so a lot of M&A will booming. So I will say it is will be a good time coming. And for facing this kind of opportunities and challenges, we have some advices or the measures can be taken by the companies. So first of all, you need to creating a didactic response team specifically for the COVID-19. And also you need to pay more attention of the risk assessment in relation to the transaction structure determination, and also you need to do something or put something as a CP, and also you need to do a risk assessment regarding the material advice event. So, and also, for the breakup or renegotiation, you need to work with your legal counsel and also your financial counsel to see whether you can or you need to continue with the transaction. So, and for the screening restriction, I would say from a historical perspective, Netherlands or the Dutch approach towards foreign investment can be seen as liberal and welcoming. And but currently, as all other countries, the Netherlands, they will also introduce some approach in the industry that are of vital national interests. So, and we listed several things downstairs in the bottom of the page regarding the increase of state intervention, including the Telecommunication Act, which was introduced by the Dutch government to protect their national interests, and for the European Union one, and also the active screening economy, the Dutch government did not actually do a lot, but they will follow the European Union's directive and regulation. And also they will have a point of exchange information, and also do some notification and obligations as required. And also specifically for COVID-19, as other countries, the Dutch government also implemented several short-term measures which helped their business to remain their employees or to remain their business. But that kind of measures would not really directly concern a direct increase or decrease of state intervention with regard to the foreign investments. So lastly, I would like to share a case study which was judged by the NCC, which I mentioned before. So the background information is then defendants intend to acquire the plaintiff's interest. And at the end of December 2019, they signed a letter of intent. So that is before the COVID-19, and after the COVID-19.
Sorry, Wendy, we are running out of time. Maybe you can skip this case. I can say I know the case very well, and
okay,
it boils down to this: that the Americans got a breakup fee of 30 million euros, and the court did not accept force majeure. So maybe you can go to your last slide, and then we have enough time for Eva.
Okay, yeah, sure. So yeah, the last one is the difference between the Netherlands and China in M&A, and I think Bart and also the panelists, you will discuss that later on during the Q&A. So yeah, and so I will just leave that to you. So thank you for listening, and yeah, I will stop.
Okay, Wendy, thank you for your interesting speech. And now the floor is to Swefang Tu. So go ahead, Eva.
Okay, thank you. Thank you, Bart. Good morning, good afternoon, and good evening. Thank you very much for inviting me So my mission today is to first give you some on-the-ground information about Belgian M&A under the current pandemic crisis. And the second part, that I will give you a brief introduction of some interesting legislative moves at the EU level. Let me start by sharing my screen.
Yeah, your PowerPoint.
Yeah.
Yeah, it's up. Go ahead.
Yeah. I think you may have heard from the news that Belgium is actually one of the worst hit country by COVID-19. It does have an impact on the M&A market. What our firm has seen is that in the first lockdown in March, April of this year, we are still quite busy, and there's still a lot of M&A deals, transactions, due diligence, also projects from China. It was not that much affected. Now, since October, November, we are in the second lockdown. And we see actually the deal amounts are, the deal numbers are starting to decrease. There are many reasons. I think the main concerns from the parties are regarding the uncertainty of the impacts on the future economic returns of the target company. So some parties, they prefer to suspend the discussion for now and wait to see next year how the situation will evolve. For Chinese buyers, there are also challenges in terms of some practical difficulties. It is very reasonable that management in China, if they cannot see or visit a company in Europe, it will be very hard for the management in China to make an acquisition decision. So that also affects a little bit some Chinese acquisition projects in Belgium. Also, from the liquidity and financing point of view, financing costs are quite high and becoming higher and higher for the buyer. That also explains that some buyers, they would want to wait until the end of the pandemic to start think about acquisitions. But on the other hand, as Wendy has said, we also see opportunities. We always say that there are always opportunities in a crisis. We see some sectors are quite resilient to the pandemic impact. Those sectors are notably the logistics sector, the pharmaceutical sector, and also the IT sector. There are still a lot of deals ongoing. I think we also see in our practice lots of distressed M&A. Some assets were quite negatively affected by COVID, and there are lots of selling of those assets in the market. We recently represent our international group to unfortunately sell their assets in Belgium and also in the neighboring countries at a very low price, with also a waiver of shareholders' debts. But those distressed M&A seems to not very appealing for Chinese buyers. And why? I think maybe one reason is that for those transactions, you need to react very quickly. So for if there's an asset on sale in the market and the seller is willing to sell it quickly as possible. And for Chinese companies, Chinese buyers, it takes time for them to decide. It takes time to get approval in China. So for distressed M&A, it seems from my experience that there are not so many Chinese buyers for the moment in the market. Also, we see there's a trend of swift change to alternative collaborations instead of acquisition. We have a client who decided to not acquire the European company, but to take a small part and also to launch a joint venture project In terms of Chinese investments into Belgium, as I mentioned, some projects were suspended for the moment, as from September, October this year. But we do see a quite large inflow of Chinese investments into the logistics sectors, especially in the south part of the country, the Liège airport. Some of you may know that Alibaba, the e-commerce giant in China, has decided to have a European hub in the Liège airport, so that the cargoes from China can land in Liège airport and then distributed to other European countries. So we see lots of requests from Chinese logistics groups or customs clearance groups or transport companies that they want to settle in Liège. They want to be close to this hub launched by Alibaba. There are also in the IT sector, we recently also was invited by Shenzhen government to give a speech about their launching of IT technology collaboration center in Europe, which will be in Brussels. And they are, despite the COVID-19, they are still doing promotions in China so that more companies from Shenzhen could join this initiative. We also see lots of collaborations in the pharmaceutical sector. Zentech is a Belgian company, and they have been collaborating with Chinese partner to launch COVID testing devices. And lastly, from my experience, we also see more and more associations in China, associations for specific industries. They are now thinking about also having an association in Brussels to be very close to the EU institutions and to be aware of the changes of EU policies. So those are the new trends of Chinese investments into Belgium. So I will briefly touch upon some very interesting EU legislative moves. Lots of Chinese companies are actually watching those moves very closely. The first one, I think you may have heard a lot from the media about the role of Huawei in the 5G network in Europe. There has been lots of discussions between Huawei and different member states. And the EU Commission has adopted an EU toolbox. The purpose of this adoption is to have a coordinated approach between different member states towards the assessment of the suppliers for 5G networking. So this toolbox has been launched, and the member states are required to identify the risks and to check the profiles of suppliers such as Huawei and how that would impact the cybersecurity of their 5G networking. Secondly, the FDI screening mechanism, but as Bart has mentioned, this was already covered in the last seminar, so I will not go into details. What I want to focus today is this white paper on foreign subsidies in the single market. This is a very important move in my view, and it's actually, I would say that it actually targets at Chinese acquisitions in Europe. September this year, the Commission has launched a public consultation on foreign subsidies. They want to check and assess whether a subsidy from a non-EU government, for instance, from a Chinese government, would have distortive impacts in the market. And they have also provided two specific scenarios. The so-called Model 2, which is on the slides here. If a foreign subsidy has facilitated the acquisition of a Europe company, and if this has caused any distortive impacts in the market, distortive, meaning that this buyer, after the buyer gets the foreign subsidy, it could offer a higher price than the valuation of the company. And this could cause incorrect valuation of the EU assets, and this could cause unfair competition with other buyers. And in the current EU law framework, there's no legal rules or legal directives or regulations which could govern this kind of behavior. And the EU Commission wants to launch a public consultation to see if there's any possible legislative proposals which could govern this kind of foreign subsidies. The definition in the white paper, the definition of foreign subsidy is very, very large. It's not just a grant from the government, but also, for instance, financing through a state-owned bank, or tax rebate, or export finance. If all this kind of financial contribution from, for instance, a Chinese government will be considered as a foreign subsidy. And this foreign subsidy can be directly granted for the purpose of acquisition. It can also be a de facto grant, which means that if a Chinese parent company has received a subsidy from the Chinese government for the past 3 years prior to the acquisition, or the following year after acquisition, and this kind of foreign subsidy can be allocated to the acquisition, then it will be considered that there is indeed a foreign subsidy which is channeled to the acquisition itself. Of course, the Commission also need to assess whether such foreign subsidy has caused a distortion in the market, whether it has give advantage to the buyer. And the whole procedure is as follows. So this potential buyer, which benefits from the foreign subsidy, it needs to inform the Commission prior to the acquisition. And the Commission will have a 2-steps review. It will first launch a preliminary review investigation to see if there is a foreign subsidy and if there is a distortion. So after the preliminary review, the Commission will give a conclusion. If it's cleared, then the transaction can be closed. And if it is not, then the Commission will go into an in-depth investigation of the deal, which means the time between signing and closing for acquisition will be very long. And at the end of the review, the Commission will decide whether they will impose some conditions for the acquisition. The conditions are very, take different forms. It can be unwinding the assets. It can be a restriction on the takeover of certain percentage of the shares, extra. So this is just a public consultation, and the white paper only provides a framework or a proposal from the European Commission. There are still lots of detailed rules which need to be considered by the Commission. So at this moment, the consultation has been completed, and based on the conclusion of this consultation, the Commission will decide what to do, whether they will propose a legislation. This is a question that remains to be seen. But I think this will have quite big impact for Chinese companies, especially for state-owned companies or companies financed by state-owned banks, which is quite a lot of cases are like this. So this is something that I would recommend to closely follow up. And last but
can you wrap up, please?
Yes, I have my clock set. This is the last part. It's also a very important one. It's the negotiation of China-EU investment. The government has said that both parties wants to close this negotiation at the end of this year. So let's also watch out the results of this treaty. That's it for my presentation. If you have any questions, please feel free to contact me through emails or WeChats. Thank you.
Thank you very much, Eva. This was an important insight into Belgium and the EU. Now we have, let us say, a quarter of an hour. Time is running out, and dinner time in China is upcoming. So you can pose your questions. Let us see in the Q&A box. So it's open now, Tom, yeah? So for questions. And while the people can log in, let me kick off with a question first to Chunqing. Are you actually saying that in a deal, be it LOI or even in the purchase or the pre-purchase contract, the approval from CESAC, from CSRC, and even from SAFE, the exchange control, should be standard condition precedent in such a document. And could it even be so that you add FDI, subsidy, or financing as a condition precedent?
I would say the following in response to your questioning. A, for the subsidy, it's a legal matter under your EU screening regulation, which is quite new and which has already, caused quite a lot of concerns to Chinese buyers. Mm-hmm. In the meantime, I have found that there is a huge fact which I am jealous of you, is that in China we have 27,000 potential buyers, even in the sense that who used to make at least one deal outside of China. So it's your clients and it's our clients. But for the subsidy, I personally and my colleagues have collectively concerned about the legitimacy of our such deal, when I just emphasized again that the main forces of purchasing EU business would be SOEs and listed company. And of course, for the SOE and the listed company, there are also quite some big overlap, you see? So subsidy, I don't want to comment too much on that. I leave this to you, to Wendy and to Tu, because it's your EU law. We don't have enough experiences or knowledge yet about this. And secondly, to treat it as a Chinese legal animal, I would say the following two aspects. Number one, back in November or the end of 2014, Chinese governments actually tried to be very pro-business, whereby they demolished the sequential approval over approval, but they replaced it with paralleled approval by combining the approval from SASAC, from MOFCOM, and so on, to make it a lot easier already. But you are right. I would say in terms of LOI meaning letter of interest or letter of intention, I would say a lot of consequences would be allowed for, conservatively, of course, legally, and also commercially, because it's buyer's market or seller's market will greatly change the mechanisms in this LOI. Okay, but if you allow me to be tentatively elaborate, I would say the following could be triggered: A, condition precedent, W and R, that's B, and C, even break up a fee might be triggered because of this kind of mechanism. Because nobody would promise that I will for sure win Chinese authorities' approval on the deal. Thank you.
Thank you, Chun-Ching. I may add from the Netherlands, as you will see in Wendy's last page, that we have in this country the phenomenon of not being able to back out of a deal unless you have very good reasons to do so. It's the fairness and reasonability test. If you if you expect problems with financing and with approvals from authorities, the takeaway is you should explicitly add that in your LOI or later contracts as a condition precedent. That works, but otherwise you are pretty much, as a buyer, you are bound to this and cannot just back out. Regarding the aspect of subsidy, indeed, that leads to a question for Ava, and that is, I understand that subsidy can be considered a distortion of economy and the deal, but what is actually, I may have missed it, but what's the threshold? What's the financial threshold of it? Is it like a deal size, under 100 million or above, or is it the amount of subsidy which kicks in?
Yeah, I think under the white paper, so again, I first need to emphasize that this is just a public consultation phase. So what the Commission proposed in the white paper is just a general framework. Lots of details about the thresholds, how to determine are not specifically mentioned. But what they mention is that when they evaluate the subsidies, they will distinguish certain kind of subsidy, which by granting the subsidy, it will already be considered as causing distortive effects in the market, such as export financing. That was mentioned in the white paper. But for other subsidies, as you are rightfully pointing out, the Commission will look into the size of the subsidy, the amounts, and also the activities of this European company receiving subsidy, to see how what are their activities in Europe, whether their activity would have such a huge impact, which causes distortions in the market. So this is mainly for European companies which controlled by Chinese shareholder, but they do have quite a big impact in the market in terms of their market size, their shares in the relevant market. So there's an indicator of different criteria that the Commission will look into. And also the Commission is also discussing whether this will be a centralized review by the Commission, or it will also be combined with a review at different countries. So they will kind of set up a threshold. So above certain threshold, it will be submitted to the Commission. And below certain threshold, it will be the supervisory authority in different countries to review. So the structure is not yet clear. They propose this and they listen to the response of different stakeholders, and then the commission will decide what to do in next steps. Yeah.
Okay, typical European Union. Staying with you, just a little question to you. You said that the waiver of shareholder debts, if I understood well, is a factor which plays a role nowadays in combination with a decrease of the price. Now, if you waive the debts from the shareholders and at the same time lower the price, I would say a typical Chinese buyer would be very interested to cut a deal quicker than he normally would do. But you say it's a delaying factor, huh?
No, I think what I want to say is that in those kind of distressed M&A, the information will be released in the Belgian market. And then when the seller wants to sell at a very cheap price, a lot of buyers in Europe or in Belgium will jump on it. But for Chinese buyers, it takes time for them to investigate, to know the target, also for their management in China to make a decision. They will not just look at the price saying, this is really cheap, I would just go for it. They also need to go through their own internal and external approval procedure. So by the time that the Chinese buyer has made a decision or has finalized their internal discussion, the assets has already been sold in Belgium. So that's one factor impacted by the COVID. If it's non-COVID period, the Chinese company will fly here the next day and they will arrange for management presentation and meetings and to see actually what they are buying. But due to the travel restrictions, those assets are very interesting for Chinese companies. They always want to receive information, but for them to really act on it, it takes time.
When you say assets, you also mean shares, huh?
Yeah.
Okay. So I may add in Wendy's last page here that in Holland, it's important. This is actually Wendy, your first point. A postponement of clearly agreed closing. It means if you don't agree specifically on conditions to delay the agreed closing date, then you have to comply. You are in the course of negotiation, and you part of the deal is that you close by 1st of December. If you don't, then the seller could jump on you with an injunction to complete the deal. Actually, the NCC case with the American tenor was exactly that. They wanted the primary claim was to get a court order to immediately close. So get on with the acquisition. Wendy, that's I understood that well, huh?
Yeah,
oh, yeah.
Indeed.
Yeah. Okay. So we have from the floor. Let me see. A question from actually an observation from Bernard Teze. Bernard, if you're in, can you pose your question, please? He's from France. Hello, Bernard.
Would you like me to allow him to speak?
Please do that.
Okay, hold on one second. I will allow him to speak. Okay, and he can give his question verbally.
Hello? Yes, can you hear me?
Yes.
Yeah. Bernard,
Yes, hello. Hello. I'm Bernard Tézé from France. It's not really a question. It was more an observation.
Yeah.
I'm a lawyer, like most of the people here, I think, all of the people. I'm based in France and I work with a variety of foreign investors, initially from Japan and now more and more from China, but still also from Japan and American, etc. And I noted that the only active foreign investor in M&A at present are the Chinese. So the Japanese, the Americans, the Germans, the Scandinavian, the Dutch, the Belgian seems to have stopped or waiting for better days or selling. And the Chinese are looking at things. They not always go to the end, but if they have money and if the president wants to go, they go, and the government, of course. So I'm wondering whether there are statistics or is there a surge? Is it only a few cases which happen to coincide at the same day, or is it a trend which is measured by statistics? I'm just wondering.
Eva, is that a question for you? You speak French at least, huh?
Yeah, I speak French.
You understand my accent, so that's good.
Yes, I understand. But I think it's good that Chinese investors are still very active in France. I don't have statistics in terms of investments from Japan or America. In Belgium, at least for Chinese investments, it's slowing down a little bit. Once if I come across some statistics, I will be very happy to share with you. But anyway, good news for you. More Chinese clients for you.
I hope it will continue.
Yeah.
Let's make it happen.
Yeah, let's hope so.
I think, Bernard, this is a trend which we can see. Obviously, there's such a surplus. Maybe Chunqing, you can say something about that. There's such a surplus of cash, liquidity in China. It must be invested somewhere outside of China as well. And the US is not very popular nowadays. So Europe is a logical venue, and France, as a big member of the Union, is an obvious target.
Maybe we have weaker companies to be taken over. Maybe that's one solution. Also, I see that the Holland, to my view, my observation is that Holland is probably the biggest continental European winner of the Brexit, because the Japanese banks, some industrial companies, etc., seems very much attracted to having their continental base in Holland, as you pointed out, for linguistic reasons and other reasons, of course.
Well, tax reasons, obviously.
Tax reasons, but linguistic reasons were pointed out.
That is true.
It's rare to have people who speak fluently French, English, and German, and you find them often in Holland.
That is true, Bernard. And as I said, the Dutch, as it's called, the Dutch sandwich, the phenomenon of an immediate Dutch holding company, hence the sandwich, can diminish or even bring down to zero withholding tax, participation exemption, and in the treaty network, dividends from Europe to China for zero. So that is a fact, and also the housing prices and office prices in Paris are going through the roof, and in Amsterdam not yet. But the more the Chinese come here, the higher the prices will be. Chun-Ching, you have some remark on this point?
I do have some remarks, actually 3 remarks quickly. Number 1, although I'm not old enough, but I benefited in the former global recession, year 2008 to 2010. I made at least 10 major international M&A deals. You know, I was much younger than now I am. Then I thought maybe when there is slowing down, downsizing in world economy, that might be a peak season for M&A. Now this year, as I just reported to you all, is truly, even this year is slowing down globally, plus pandemic, then M&A deal actually is still quite vigorous. So this is my observation. And number 2, I don't want to talk any politics, but EU, so that's why I appreciate the idea of organizing such an event. We should have done more such events, that Europe is going to be more important than USA or Australia or Canada or even New Zealand, due to obvious reason. So, because I would say European people might be more mature. Sorry, I don't want to annoy anybody. So this is also the second comment. It's culture. I'm not talking about any politics. And number 3, regarding French, I would say Dutch people doing very well in China. Small Belgium, small country, also doing very well in China. Very reserved, different than, you know, Dutch. And the French people also doing very well in China. I made a deal. I was working for L'Oreal for 8.5 years, and also for Schneider and so on, Alstom, Arriva. I don't speak any French, I'm sorry. But I can tell you, so many business are potentially targets for Chinese rich people, even also our SOEs and listed companies. So I promise you. That's my observation.
Okay. Rhonda, we are now at 11 o'clock.
Yes.
So European time. So I think we must really do a cutoff. If there are no more questions, then let me already thank the speakers for their valuable thought sharing with us. And I think now I don't see Jack Lee anymore, so we can't sing a goodbye song, unfortunately. I won't ask Winston to do this. So thanks, Jack, also for making this happen, and especially Rhonda for all the logistics, which are very valuable in these hard COVID times. So it's an important instrument we have, and you are an important person in the organization. And I want to thank Wang Tong. So Tong, she helped me greatly with the putting together the things and the let's say the digital side of it, and also the content together with Wendy. So thanks a lot, everyone, and I hope soon we will have a next conference, a next webinar, and maybe April, May in Shanghai, the IPBA conference. and then we can all go there physically. So thank you, and we're signing off now.
Thank you.
Bye-bye.
Thank you. Thank you all. Bye.
Thank you all.
Bye.
Very good organizing. Thank you.
Thank you. Thank
Thank
you.
you. Thank you.
Bye.
Bye.
Bye-bye.
Bye. 好的。啊，江宁辛苦了今天。景俊。